Administrative law is actually important in terms of the separation of powers because it highlights the role of the judiciary in controlling and regulating executive power by providing for judicial remedies in the event there are breaches of governmental duties. Separation of powers assumes that the executive and administrative agencies do not have the full freedom to exceed or abuse their powers or to act unreasonably. Because if they do, then you have the judiciary acting in that role of being a check and a balance on the exercise by the executive of its coercive and broad powers which affect the citizens or the citizenry every day and pervasively. Administrative law also emphasizes the role of the judiciary to interpret and enforce the provisions of statutes which impose duties and confers powers on administrative agencies. And this role obviously is linked to the separation of powers. Now, if you go back to the notion of separation of powers, the idea being that in the framework of government that we have, and you have three key branches of government, the executive, the legislature, and the judiciary, you're trying to avoid a situation where you have a single government institution which wields the power, for example, to legislate, meaning pass the law, which then has the power to enforce the law and even interpret the law. Because the moment you have a singular institution which is able to pass the law, enforce the law, and interpret the law, you have what is known as a despotism. Government agency, therefore, that bows to no one. We can also examine administrative law from the viewpoint of its scope. And you look at administrative law typically from the viewpoint of judicial review. In fact, the scope of administrative law is broader because it protects the rights and interests of peoples and corporations in their dealings with government agencies in three ways. One of them is in relation to the review of decision making, which we've already discussed. And this permits people or those who are aggrieved by government decisions to challenge those government decisions. The second aspect actually of administrative law involves the protection of information rights. And this enables the public to access government documents, for example, through freedom of information legislation. Another aspect of administrative law, which we'll actually also be examining in this course, also involves public accountability of government processes, which seeks to ensure that government processes are accountable and that they are proper. Concerning the review of decision making, there are various ways by which decisions of the executive government are subject to review. One is by judicial review, and this is by applying to a court. Another way of having decisions by the executive government reviewed would be through an administrative review process by an administrative tribunal over the merits or legality of a decision. Decisions can also be reviewed by filing a complaint to the ombudsman or a human rights agency. And finally, there can also be a review of decision making through the internal review processes within a government agency. It is also a part of administrative law to be able to regulate the use and handling of information within government, for example, through privacy legislation. And administrative law also confers a right to have reasons for a decision stated in writing through administrative law or administrative review legislation. And it also protects the disclosure of information about unlawful or unethical activity without threat of disciplinary, criminal, or civil law sanctions through whistleblower legislation. Government processes and activities may be held to account by the public through anti-corruption agencies, human rights commissions, specialist government inquiries, and through statutes which regulate the drafting of subordinate legislation.